Your Honor, I'm guilty.
Your Honor,
no, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Your trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail. Can I get your appearance?
Yes, thank you, Judge. Andrew Mickus on behalf of Miss Owens, P76268. Miss Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right. Did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Miss Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, and Mr. Zick will be dismissing the other matter.
This case right here is the definition of a courtroom roller coaster. From the very first second, Miss Owens comes in hot, opening her mouth before the judge can even finish a sentence. And trust me, when a defendant enters a courtroom already arguing with themselves about being guilty or not, you know you're in for a show. Miss Owens isn't new to this. She's got a track record long enough to qualify for frequent flyer miles in the criminal justice system. But today, the judge has no time for games. What starts as a simple plea turns quickly into a battle of contradictions, confusion, and complete chaos. The judge really tries, to keep things orderly, but Miss Owens keeps flip-flopping between guilt and innocence like she's auditioning for a soap opera.
We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that figure is going to be 0 because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
Just gonna okay. All right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you
Here's where everything should have gone smoothly. The attorneys are calm, collected, and acting like professionals trying to wrap up what should be a straightforward plea deal. They outline the agreement, talk restitution, and even make it clear the items were recovered. At this point, most defendants simply answer the judge's questions, admit the wrongdoing, and move on. But Miss Owens? Oh no, she's not going to let this be simple. Watch closely. As soon as the judge starts asking her to confirm the facts, she begins wobbling. It's like she wants the benefits of a plea deal, but not the part where she has to admit she did something wrong.
Take some merchandise that wasn't yours?
Yes, sir.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was I think.
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
This is the moment the judge and her own attorney realize things are going sideways. Fast. She admits she went to Walmart. She admits she walked toward the exit. She admits there were items. But then suddenly she's unsure whether she scanned them, unsure whether she intended to take them, unsure whether she even knows how self-checkout works. This kind of vague, shifting explanation is a courtroom red flag. Judges need a factual basis. Clear, consistent admissions that match the evidence. Instead, Miss Owens gives tangled statements that contradict each other every 15 seconds. You can see her lawyer trying to coach her gently, trying to rescue.
All right, I can't accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
no, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. If you think you're going to sit here and tell me that you didn't do anything wrong and think I'm going to accept your plea, you're sadly mistaken. I'm happy to have a jury trial. I like nothing more than a jury trial. You either want to accept a plea or you don't. And you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item. And honestly, it wasn't to steal the item. I tried to pay for the item.
And here we go, the breaking point. When a judge says, I can't accept the plea, that's not just procedural language. That's the justice system throwing its hands up and saying, enough. Miss Owens keeps insisting she's guilty, but every sentence she speaks is actually a not guilty explanation. It's like watching someone step on the gas and brake at the same time. The judge tries to guide her, tries to clarify, but she can't stop backtracking. At this stage, she's dug herself into a hole so deep that even her attorney wants a timeout, literally asking for a breakout room to try to save this sinking ship.
All right, so that's a not guilty plea. So, okay, we're going to just go ahead and set these both for jury trial. But the second
one, I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan $250 worth of items?
No, I didn't say accidentally. There was a computer or something wrong with it.
No, on the first case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident.
Your Honor, I'm guilty.
We're going to jury trial. I'll set a jury trial date and we'll see you on that date.
Your Honor, if I may have an opportunity briefly in a breakout room with my client.
I've had enough of your client, quite frankly, and the games she likes to play. She's lucky I didn't revoke her bond the first time, and now she wants to play with whether or not she's responsible of this or not. And no, I'm not comfortable taking a plea. She's made it clear.
Now notice this carefully. When they come back on the record, things start out a lot cleaner. Miss Owens is giving direct answers, saying, yes, Your Honor, hitting the right points, and finally admitting intent. This is the courtroom equivalent of hitting the reset button. Her lawyer clearly had some firm words with her off camera. But even here, you can feel the tension because the judge is listening very closely for any sign of the previous backtracking. One slip, one contradiction, and he would have shut all down again. Luckily for her, she finally delivers a version of events that the judge can legally accept.
She didn't do anything. We're all set. You'll get your jury trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Mr. Mikos, I'm sorry. I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial. All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mikus, P76268 on behalf of Ms. Owens.
Miss Owens, tell me your name.
J.C. Owens.
Miss Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Miss Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal.
Once the judge accepts the plea, you can hear the shift in energy. It's calmer, procedural, almost peaceful after the chaos we just witnessed. But don't miss this part. The judge immediately orders a probation evaluation. That's not random. Judges do that when something in the defendant's behavior raises concerns, whether it's honesty, stability, or consistency. It's his way of saying, before I sentence you, I want professionals to take a deeper look. And considering how Miss Owens struggled to give straight answers for nearly 10 minutes, it makes sense. The judge wants to understand what's going on beneath the surface.
I think, I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff. Toiletries, yeah.
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
Yes, Your Honor.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230962. That case will be dismissed per the plea. Meet with the probation department for a pre-sentence investigation. You're going to get notice of that in the mail.
Okay.
And you're going to meet with them. And I'm sorry, Mr. Mikos.
No, go ahead, Judge. I'm sorry.
Yeah, I think we need to evaluate.
This section highlights exactly why the judge hit his limit. Owens kept toggling between it was an accident and I intended to steal, depending on which version she thought sounded better in the moment. But courtroom truth isn't a choose-your-own-adventure. You can't be guilty and innocent simultaneously. Her lawyer knows this. The prosecutor knows it. Even the judge spells it out plainly. But Owens keeps drifting, digging deeper every time she opens her mouth. This is how defendants accidentally turn minor cases into major issues, by refusing to give a consistent story. And honestly, you can't blame the judge here. After watching her dance around the facts for nearly 10 minutes, he had every reason to lose patience.
So you're going to meet with the probation department, Miss Owens, and they're going to contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
Okay. We're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Sounds good. Thank you, Judge, and thank you for your patience today.
All right, I'll see everyone at sentence.
And there you have it, one of the most chaotic plea hearings you'll ever see. What should have been a routine 5-minute guilty plea turned into a legal maze of contradictions, confusion, and courtroom frustration. The judge gave Miss Owens multiple chances to lay out the facts, but every time she spoke, the situation unraveled a bit more. In the end, the only way forward was a full reset and a more structured plea, something she finally managed to deliver. If you found this courtroom meltdown as unbelievable as we did, hit that like button, drop your thoughts in the comments, and make sure you subscribe for more jaw-dropping courtroom breakdowns just like this.